Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Oxford University Press, OUP. It's an important book and one I found fascinating. It's called The Framework of Corporate Insolvency Law. It's been written by Hamish Anderson, and Elizabeth and I have discussed this book and come up with a title. Elizabeth, in fact, wrote the main review. But we've come up with a title, Corporate Insolvency Law, a seasoned practitioner offers new perspectives and insights. And that's exactly what you're getting with this book. I think it's an important book. It's not a big one, with a hardback, as you can see there. The spine, there's nothing on the back. The book itself runs to something approaching, there we go, 300 pages, something like that. It's actually produced the index by reference, paragraph numbering rather than page numbering, so you can find things quite quickly. See, even at the back, there's the paragraph numbering and some footnotes at the bottom. We go to the front of the book. There's the main front page there. There's a nice little dedication. I always like to show the dedications because a lot of people are involved in these books and they take a lot of work. There's a foreword which is well worth reading, which gives you a fairly good feel. It's been written by Lord Justice Richards, who will be known to many of you. Very important comments he makes. Then there's a preface, which the author has produced in December 2016. He's tried to state the law as at the 1st of December 16. I mentioned this in the review, but there are further things that are sort of coming forward after that date, so he's tried to include what he can. There's the contents section there. You see the various chapter headings running all the way through. A lot of detail in this book. 22 chapters in all, ending with cross-border insolvency, which is a subject, of course, in its own right, and also published, I believe, by OUP. Then the tables of cases, which you've got there, starting with the UK cases, then a whole range of other cases, international jurisdictions, of course, then a table of legislation, and then after that, again, you've got EU information as well, and other countries, United States. Very useful list of abbreviations, which I found very helpful indeed. And then you've got the structure. You've got a nice little short index at the beginning of each chapter, and then you've got the actual subheading scope of the book, and then you've got footnoting as well. And you can see the paragraph numbering at the side to find things. And that's basically how it runs all the way through. A very important book. I think a book that is a subject that you do actually need to have some familiarity with, because there are some terms used which may not be particularly familiar to quite a lot of people. But I do feel that this book is an important contribution to insolvency law, and certainly, obviously, corporate insolvency law in particular. And I think it's giving a fresh approach. That's certainly what both Elizabeth and I thought. Anyway, what do we say about the book? We say, well, English corporate insolvency law, explains author Hamish Anderson, meets the social and economic need for rules to deal with the assets and undertaking of a defaulting debtor company in a way which does not stifle economic activity. Expert commentary on said rules is delivered aplenty in this erudite new legal text from OUP. Now, when we say that, we're talking about the basic view which the courts have always adopted, which is they don't want to interfere. They really don't wish to interfere with the economic activity of a company unless they have to. Now, if you think about it, that's a sensible way to look at it, because at the end of the day, if they have to, they're going to have to impose something which the parties don't really want anyway. It's better let them get on with it. And that's always been basically, I think, the approach which the judiciary have adopted. Anyway, with regard to corporate insolvency law, the approach here is both insightful and practical, and should certainly pique the interests of practitioners specialising in this field, in which much has happened over the past 40 or so years. During this time, the volume of academic attention generated in this area has spectacularly increased, notably following the repercussions of the financial crisis, or should we say crises, of 2008. Now, writing the foreword, Richards, Lord Justice David Richards, remarks, quote, that it's striking that for all the contemporary significance of the issues and the mass of new law, recourse is frequently necessary to cases decided over the last 200 years. And he adds that the present law, although new in many respects, is underpinned by some long-established principles. He's absolutely right, because that's the basis, of course, of what I understand to be company law, having read it as an undergraduate and having practiced it as a barrister. Clearly there are these established principles which have not really changed that much. If you think about the basic ones, they're still there, Salomon and so forth. Of course, you've got the minority interest cases as well, shareholders and so forth. Now, focusing on such principles, the book deals with the salient aspects of corporate insolvency law, including obviously the purpose and functions of the rules that we've got. The result, says the author, is neither a textbook nor a reference book. It's complementary to both, and I think that's right, because there's always a problem with these books. They are specialist, but what he's trying to do is he's giving a lot of good advice, in my view. So it's not just a textbook, it's going to be much wider than that, because it's something you would wish to refer to, subject to whatever the problem is that you may possibly be facing, either as a company or as counsel advising on a particular knotty problem. The book was completed following the author's retirement from Norton Rose Fulbright in 2017, earlier this year in fact. We're recording this in the summer of 2017. The fruits of his expertise have been garnered over a working lifetime, are actually here placed at your disposal, and it's a very good job he has done that, in my view. But why, he asks somewhat rhetorically, have insolvency law at all? Interesting point, that one. The answer is that the credit, which is indispensable in a free market economy, brings with it the possibility of default and, one might add, the troublesome consequences. Now, over about 300 pages or in 22 chapters, the author fleshes out the framework, functions and objectives of corporate insolvency law, its underlying concepts, and fundamentally the meaning of insolvency, covering such matters as liquidation, administration and CVAs, company voluntary arrangements, that is. There is of course much more besides in what is a very detailed book, including comment on expenses, creditors' rights, the ranking of claims, and the final chapter, which I've indicated earlier, which is on cross-border insolvency, which is a technical subject in its own right, and certainly something which will be with us for a very long time, whatever happens between ourselves and the other member states within Europe. Now, general interest and wry comment for many a reader is the chapter on Phoenixism and pre-packing, two pet hates within the business community and elsewhere. Now, this is really rather good. Phoenixism refers to firms which rise phoenix-like from the ashes of their insolvency and proceed in any number of cases to carry on business as usual. Pre-packing refers to the pre-arranged sale of a business immediately an administrator is appointed. You can see the imagery of this. The intriguing details are to be found in this book, which indeed functions admirably as a complement to other reference books in this subject area. Now, let me conclude by using a quote. He says, the author says, "I hope that my book will assist the academic study of insolvency law and equally be of use to all who apply it. And given the scholarly analysis the book provides, as well as its accessible style of writing, there is little doubt that this hope will be realised. And in the considered opinion of Richards, the book is an important addition to the literature on what is often a vexed subject, concluding that a second edition will soon be needed." Well, that's nice of him. There's a lot more work involved there then. The publication date is stated at 2017, and as I've indicated, I'm actually recording this in the summer of 2017. Let's just have another look at the book. There it is again at the front. As fine, I think there then. Now, I'm just opening it in the middle. I'm looking here at, looking here. This is the inherent jurisdiction. You can see how the book is structured. You've got the paragraph numbering. You've got extracts from the case law, because there's a lot of case law in this area. Then you've got the annotated footnotes at the bottom. But there's a lot of information. There's a lot of scholarship has gone into this book here. There we go. You can see more information. This is the challenging the office holder's conduct. Restorative avoidance. There we go. An interesting area. Disqualification of directors. Always an important one again. I've always felt perhaps that the Company Directors Disqualification Act is a little bit toothless at the end of the day when you look at some of the people involved. And I don't want to say too much about that because obviously have been involved in making representations on the behalf of directors. But again, I don't know whether that is a satisfactory way of dealing with it. But again, these questions, this is the framework of corporate insolvency law, these questions are the ones that are raised by Hamish Anderson. Very grateful to him and OUP for producing this book, and a very big thank you to all concerned. Bye-bye.